With the Courtney Clenney hearing moving along, albeit kind of slowly, and I thought this could be a great opportunity to use the context of the Courtney Clenney case for an educational moment. So, what we're going to do in this video is we are going to talk about what an Arthur hearing is and why it's different than a bond hearing. We're going to talk about Florida murder versus manslaughter and what the underlying elements of second-degree murder are. We're also going to talk about justifiable use of force in Florida. So by the end of this, you'll have an understanding of why in November 2022, Courtney Clenney had what looked like a bond hearing. It's technically an Arthur hearing. We're going to go over those differences, but you're going to understand why it was almost like a mini trial. You'll also understand why she was charged with second-degree murder and what the state has to prove those elements of second-degree murder in their case against Courtney Clenney. You're also going to understand the nuances of justifiable use of force in Florida. So by the time we get through this video, using the Courtney Clenney case as an example, you'll have a really good understanding of some of these concepts and a better understanding, if you're interested in the Courtney Clenney case, why things are moving and being played out the way they are. Now, before we move forward, just some housekeeping. I'm recording this before a status hearing that's happening in the Courtney Clenney case on May 14th. So that's 2 days away from the time I'm recording this. If you're watching this before that, subscribe and hit the bell because you can watch that with us live. We're going to go through some of the same concepts that we talk about today. They're going to come up during that hearing. If you're watching it after and want to go check out that hearing, go find it on my channel. I have a whole Courtney Clenney playlist. Secondly, I'm also going to be doing a rewatch, a revisit of the November 2022 Arthur hearing, bond hearing, whatever you want to call it, with Courtney Clenney. It took about 6.5 hours, 7 hours. We're going to watch it on 1 1/4 speed, but we're going to go through it with some analysis from not just these concepts being applied and explained throughout, but we're also going to weave in some of the things that we know now that we may not have had information on while the hearing was initially taking place. So we'll have a much greater understanding. And again, since an Arthur hearing is a little bit of a mini trial, it's a great preview at some of the things that both the state and the defense will be arguing at the actual trial and how they're making those arguments. So if you want to tune in, I'm going to do it in 3 parts. Make sure you subscribe and hit the bell, or if you're watching this way later, you can check that all out in the Courtney Clenney playlist on my channel. So first we're going to talk about Arthur hearings and why Courtney Clenney had one in November of 2022. Again, that's old news, right? That's already passed, but it's a great example. People had all these questions about why are they talking so much about the evidence? It seems like they're going through a trial. It's weird. And that's a good observation because at a typical bond hearing, it's much quicker. You know, is someone a threat to the community? Will they show up for their next hearing? Will they show up in person? Or are they a flight risk? Right? You establish those things, you get in and out, boom, you're done. But what's Courtney Clenney being charged with? She's being charged with second-degree murder. Now let's take a moment and hone in on why that knife is so important. On one hand, obviously, for using a knife, you can't play oblivious about the threat of serious bodily injury or even death being inflicted upon whoever you're using the knife against. But if you're charged with a felony and use or attempt to use a weapon in that felony, your felony can be reclassified. So even though she's charged with a second-degree murder, you'll note that she's actually charged with a first-degree penalty, which is where we're seeing that up to life sentence. So that's why her charge says murder in the second degree with weapon. Because with this weapon, you may hear the term weapon enhancement. Instead of, the cap of 15 years max for a second-degree murder charge, Courtney's cap is actually up to life because there's this weapon attached to it. So in Florida, what happens is many crimes are actually eligible for release on bail. Petty crimes, misdemeanors, whatever the case may be. And in Florida, the way they look at it is if a charged offense can carry a life sentence or a possible sentence of capital punishment, so a death penalty, then that individual is supposed to remain in custody until their trial. In other words, it's not typically a bondable offense. But in Florida, when a person is arrested and charged with a crime that's typically a non-bondable offense, they do have the right to ask for an Arthur hearing. So even though you're initially going to be denied bond if you're charged with something that could carry a life sentence or be up to the death penalty, a judge could consider granting you an Arthur hearing and you could have one. So if there wasn't a knife involved, if there wasn't a weapon involved that gave us this type of sentencing enhancement, Courtney wouldn't be facing life in prison, and then we wouldn't have an Arthur hearing as opposed to a regular bond hearing. So just a small detail there, but it explains a lot of the moving pieces that are happening with this specific case. And the whole purpose of that hearing, the Arthur hearing, is going to be for the judge to determine, hey, is there a circumstance, is there an exception here where the defendant should be released pending trial? Now, at this Arthur hearing, the defense needs to prove two key things to the judge. This is not going to be heard in front of a jury. Arthur hearings are in front of a judge. So the defense attorney is going to get up there and they're going to make their case that, one, the charges placed on the defendant do not have significant enough evidence to prove guilt. So it's a sufficiency of evidence argument. And when it comes to sufficiency of evidence, what that means is whatever is being charged of a defendant, the underlying elements required to prove that offense, is there enough evidence that they can establish that those elements are met? So that's the first thing that a defense attorney is going to have to go in and argue in front of a judge is the evidence is insufficient to prove whatever my client is charged with. Two, the second thing is the defendant does not pose a danger to society. Zooming into the Courtney Clenney case, if you guys already paid attention to the bond hearing, and guys, whether you did or not, come rewatch it, because you guys, if you've been following the case, you know a lot more. If you're new to the case and just trying to learn, it's a great thing to go and revisit, so come do it together with us throughout this week. We're going to do it on 3 separate days in live stream blocks. But whether you watched it while it was happening or you saw some reporting about it, it was a pretty big deal. And part of the reason it was a big deal is because Obumseli's family was there, Clenney's family was there. There were a lot of people present in the courtroom that's not necessarily the case for some of the ongoing hearings. But one of the reasons that friends and family on the defendant side are encouraged to attend this type of hearing specifically is it's something that in and of itself, on its face, can help show the judge that members of the community, members of the family, do not fear this person. So, for example, if it had only been Courtney Clenney's family that showed up, and we'll see the dad's going to actually take the stand. He's a witness at the Arthur hearing. He says, I have no problem with my daughter coming home to stay with me. I'm not afraid of her. She's not a harm to anybody. Having your family members as the defendant, your family and friends there to support you, shows that you're not scary, that these people do not think that you're scary or a threat or dangerous. So a defense attorney will typically try to coordinate and arrange and make sure that family members and friends are aware of these dates and make sure they can be there and show up and show their support. Now, during the hearing itself, there's 2 distinct phases, a phase 1 and a phase 2. Phase 1 is going to be what seems like that mini trial. Wow, why are they going through all of this here? It's not even the trial yet. Now, the judge will get to consider witness testimony and other evidence presented by both sides, depending on what each party wants to bring forward at this type of hearing. But the prosecution actually bears the burden of proof. And the standard there is a great presumption. So with phase 1, we're really looking at what's being charged here. Is there sufficiency of evidence? And is there substantial evidence, maybe not rising to the level of guilty beyond a reasonable doubt, but substantial enough that it's beyond just a simple probability, 50-50 probability, that the defendant is guilty? Is there enough evidence that could go to show that? Phase 2, the judge now has to decide, is a discretionary bond appropriate? So all of the things relating to this specific charge at hand considered, what about a prior record? Does the defendant have prior offenses? The seriousness of the crime could also be considered, but we know if we're at an Arthur hearing that it's pretty serious. And also whether or not the defendant poses a flight risk or is a danger to society. So the judge will make a determination if bond should be granted at all, and if so, they have the discretion to decide what amount that bond should be. So if you hear someone say Arthur hearing and then the next person says bond hearing, well, an Arthur's hearing is still a bond hearing. It's just involving a more serious offense where life in prison is on the line or capital punishment is on the line. And as such, an Arthur hearing, especially that phase 1 part, guys, is typically a lot longer. A typical bond hearing could just be that phase 2. Is there a prior record? Are they a flight risk? Blah, 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 blah. So an Arthur hearing is a bond hearing with a lot more on the line, but it's still just a hearing. It is not a fact-finding. So whether the judge decides, hey, we're going to keep this person in custody pending trial, or we're going to let them out on bond if they can pay the bond, that's not a fact-finding thing. So the judge isn't making an underlying determination about the evidence that's presented at this Arthur hearing as being factual or not. That's still going to be for the jury to decide when trial actually takes place. So even though we're calling it a mini trial, because it seems like all the stuff is being presented, it is not. There is no fact-finding element there. That's the final important distinction there, I think, between Arthur hearing, bond hearing, and actual trial. And now we're going to get into the differences between Florida murder and manslaughter. What are the differences? Why did the state charge Courtney Clenney with second-degree murder versus first-degree or with manslaughter? And again, a lot of this will be great information even if you're not following the case. We're just going to use the Courtney Clenney case as a framework for understanding. Because a lot of times what you'll see is the state wants to choose the appropriate charges that they believe a jury will be able to agree to, their argument, their theory of argument for the case, that hey, we've proven each of the elements required for this charge beyond a reasonable doubt. And the defense will make the argument, hey, not only is my client innocent or whatever, but the elements based on the evidence the state is presenting, the elements aren't sufficient enough for what they're charging my client with. So charging is very important because those elements, those underlying elements, are where the defense and the state come in and play this game of tug of war. And I think most importantly, let's start with the definition of homicide. So homicide is just a broad term used to describe the act of killing another person. Homicides can be considered legal. Now, murder is the illegal killing of another person. It can be premeditated or not premeditated. The defining element of murder that distinguishes it from something like manslaughter is malice aforethought. So if the killing was made with malice aforethought, then the killing is considered murder. So malice aforethought can exist when someone intentionally inflicts serious bodily harm on somebody and that infliction results in the death of that other person, or when that person behaves in a way that demonstrates extreme, reckless disregard for life, and that behavior results in the death of the victim. So again, all murder in Florida involves malice aforethought. The difference between first-degree murder and second-degree murder is that, again, first-degree murder will require not just malice aforethought, but also an element of premeditation. In Florida, you can also be charged with first-degree murder if you end up killing somebody in the course of another violent felony like robbery, burglary, and while you're doing that, you end up killing somebody. Murder in the second degree is the intentional killing of another human being with malice, but not premeditation, without premeditation. So there's no deliberate planning to do so. So because Courtney Clenney is charged with second-degree murder, the state does not need to make a case for premeditation. It's not an underlying element of the crime. I think it's also important to talk about what manslaughter is defined as in Florida, and that's just a general learning opportunity, but also you will see, not just at the Arthur hearing, but I'm assuming also at trial for Courtney Clenney, the defense is going to make an argument that not only is my client innocent because they were justified in their use of force against Christian Obumseli, but if anything, what they did would not rise to the level of second-degree murder, and it should only be considered, at most, manslaughter. I'd be very surprised if we don't see this type of argument come into play in the trial. So if a homicide is committed with premeditation, intent, or during the commission of another violent felony, then you're looking at first-degree murder. If a homicide occurs with intent, but not premeditation, you're looking at second-degree murder. And if there's no premeditation or intent to kill or intent to cause serious bodily harm that ends up resulting in the death of somebody, or behavior that is intentionally acting in disregard of human life that ends up killing somebody, if that's not there, then it's manslaughter. And I think this is a really good time to use the framework of the Courtney Clenney case as an example because it can be kind of confusing to say, well, if murder 1 has intent and premeditation and manslaughter is no intent, then what's this gray area? So what the state is charging Courtney Clenney with is essentially the unlawful killing of a human being perpetrated by an act imminently dangerous to another and evincing a depraved mind regardless of human life, but no premeditation. The elements of the crime charge against Courtney Clenney, second-degree murder, can be met without saying, hey, Courtney Clenney intended to kill Christian Obumseli. That doesn't need to be proven. And assuming a defendant has said, yes, it was me that killed this person, there are 3 defenses to this, to second-degree murder. 1 is a justifiable use of deadly force against the felony committed against a person or property. 2, an excusable homicide committed by accident. And 3, a spontaneous or negligent killing that might qualify as manslaughter instead of murder. So according to Courtney Clenney's own statements to police, she didn't intend to kill him, she just threw the knife to keep him away, and her defense attorneys are not only going to make an argument of justifiable use of force, but I think we'll see a little bit of argument towards, hey, this was spontaneous, it was in the moment, it all happened very quickly, and this would be more in line with manslaughter if it's not justified as a second-degree murder. So those are just some things to put your radar out for if you're going to rewatch the Courtney Clenney Arthur hearing with us or watch the trial. Now, what we're really going to get into here is what's up on my screen, and that is how Florida defines justifiable use of force, because that is the main defense that Courtney Clenney is going to use at trial. And it's also just some good information to know in general if you ever visit Florida, if you live here, or just want to know a little bit in general about how justifiable use of force works. Again, every state's going to have their different nuances between their justification laws, but hey, either way, we're going to learn something here. And some of it may only be applicable to Florida, so know your own state, but at least you'll have it in the back of your mind if you plan to follow the rest of the Courtney Clenney trial play out. Everything we're going to be talking about from here forward is about justifiable use of force. In other words, the self-defense argument that Courtney Clenney and her attorneys are putting forth. We're going to skip this top paragraph because it deals with non-deadly force. We're going to go to paragraph 2 here, which deals with deadly force. So a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. So here we're alluding at the key elements of a justifiable use of force defense. So avoidance, there's no duty to retreat if you're in a place you have the right to be. Reasonableness, innocence, imminence, proportionality. And I think it's also important to look at some exceptions here under this paragraph here: home protection, use of threatened or deadly force, presumption of fear of death or great bodily harm. Subsection 2 says a person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to himself or herself or another when using or threatening to use defensive force that is intended or likely to cause death or great bodily harm to another if. And it doesn't apply if the person against whom the defensive force is used or threatened has the right to be in or is a lawful resident of the dwelling, residence, or vehicle, such as an owner, lessee, title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person. So what do we mean? Even though there may not be a duty to retreat, Courtney Clenney isn't afforded the home protection benefits of a justifiable use of force because there was nothing actually in place, that there was no protective order in place. She tried to ask for one 2 days prior. She was told to go down in the courthouse and get one. They couldn't do anything for her on the spot because she didn't say, she wouldn't say. They asked, but she wouldn't say that he had been violent with her, that Christian Obumseli had been violent with her right then and there. So they said for other situations, you need to go down the court and get a court-issued order. We can't just arrest him here. And because Christian Obumseli was staying there, he had a reasonable right to be there as well. All of these other protections that may have otherwise be afforded to Courtney Clenney if he showed up and he hadn't been living there and he wasn't welcome and or he had an order of protection where he wasn't supposed to go near her. Some of these benefits here could have extended to her justifiable use of force. So, thought that was important to go over, at least at a glance, to demonstrate why it's absent in Courtney Clenney's case. These things can't help her case because they don't apply. Now, what I really want to talk about here is use or threatened use of force by aggressor. The justification described in the preceding sections of this chapter is not available to a person who, and then the important sections I highlight here are, initially provokes the use or threatened use of force against himself or herself, unless A, such force or threat of force is so great that the person reasonably believes that he or she is in imminent danger of death or great bodily harm, and that he or she has exhausted every reasonable means to escape such danger, other than the use or threatened use of force, which is likely to cause death or great bodily harm to the assailant, or B, in good faith, the person withdraws from physical contact with the assailant and indicates clearly to the assailant that he or she desires to withdraw and terminate the use or threatened use of force, but the assailant continues or resumes the use or threatened use of force. Now, this is going to be a huge back and forth tug of war between the state and the defense in the Courtney Clenney trial. Why? Because only 2 people were in the room at that time. You had Courtney Clenney and Christian Obumseli. Courtney Clenney is alleging, well, he grabbed me by the throat and pushed me against the wall. I was scared. I told him to step back, and then I threw a knife at him. That's her story. We don't have the other in-room witness available to testify. He's no longer on this earth. And then we have Mom, who was on the phone for portions of it. Mom had said she heard Courtney screaming about Christian lying about something. There's also a security guard who was standing outside the room. It was one of the female security guards. She said she heard the arguing and then it suddenly got silent right before around the time that Courtney Clenney ended up calling 911. Now, a lot of times people think of the initial aggressor. They think of who was the first one that initiated physical contact, harmful contact with the other person. But at least in Florida, there's this idea of provocation. And you see that highlighted here in subsection 2. So in other words, justification, the justification defense, your justifiable use of force to protect yourself, is not available to a person who initially provokes the use or threatened use of force against himself or herself, right? Unless that person reasonably believes that he or she is in imminent danger of death or great bodily harm. Not just of being poked, not just of, someone pulling your hair out or something like that, but reasonable fear of death or great bodily harm, and that he or she has exhausted every reasonable means to escape such danger other than the use or threatened use of force, which is likely to cause death or great bodily harm to the assailant. So she could provoke it, and she'd be in trouble. It'd be her fault. But if she withdrew from the contact and said, no, I'm done. I'm not doing this anymore. Let's call a truce. And then the other person continues, then it would be justifiable again. And with the jury as the fact finder, I think this will be the most contentious element, the most contentious issue for them to have to decide and decipher. Courtney Clenney, it's not guaranteed that she's going to take the stand. So evidence of things that she may have said or what led up to this moment or her own actions, we may only get information on based on what else another witness can get in, like a detective. Christian Obumseli won't take the stand. If mom takes the stand, she's in a tight spot because she's already told detectives, hey, I heard Courtney yelling at Christian right before this happened, right before he was killed. She was yelling about him, something about Christian lying. And if the thing that's starting the argument is someone accusing someone else of lying, who provoked it? And the defense would then, if the defense is concerned that the state is going to be able to convince the jury that Courtney Clenney was the one that provoked the altercation, she was the one that started it, the defense is going to have to make an argument and get ahead of that and overcome that by saying she tried to withdraw from the escalating conflict, but couldn't do so, and thus had imminent fear of death or great bodily harm. And that even though she may have provoked the argument by starting it, she was still justified in her use of force against Christian Obumseli, because in that moment, she reasonably tried to withdraw, to leave the conflict, to communicate with Christian Obumseli, I don't want to do this. And I'm not sure how they're going to be able to prove that. But that could be a problem from her, because she describes him as getting off of her and letting her stand back up. Even in her own words, a juror taking that at face value could say, well, him getting up and distancing himself is him trying to relieve the conflict and withdraw from the conflict. And then we have the theory, well, she threw the knife, indicating I was distant from him. I kept my distance from him, but he started coming near me. I saw the whites of his eyes. If someone takes that at face value, her description of those events at face value, perhaps they could conclude that Courtney tried to keep her distance from this conflict and wasn't the one running up and pursuing it. But if someone doesn't believe that at face value, they don't believe that the knife was thrown, and they instead say, well, Courtney said he gets up and suddenly there's 10 feet of distance between them. She stands up. Somehow there's a knife plunged in him with 8 to 10 pounds of pressure. I believe that was a plunging rather than a throwing. The motion would be, it would suggest that Courtney Clenney did not try to withdraw from what was occurring. And this exception, that even if she was the provocateur, there's an exception that she could still be justifiable in her use of force. That interpretation, depending on how the jury interprets it, this exception wouldn't exist for Courtney Clenney. If they don't feel she tried to withdraw, she would then just be the provocateur without exception. So it's a very, very interesting paragraph. And not all states, some states, guys, the initial aggressor is the physical aggressor. It's not just someone that gets in your face and is screaming in your face and it just escalates from there. Like, hit me first, bro. Sometimes the person that says, hit me first, bro, they didn't want to be the first one to actually throw the punch. They were taunting the other person to do it. Some states don't play that. Florida doesn't play that argument. So here, Courtney could be the initial provocateur just because she started the argument. Even if the first physical contact was Christian saying, "Get away from me," and shoving her. He may have been the first one to make physical contact, but that doesn't make him the aggressor by Florida statute. And if Mom heard over the phone Courtney Clenney screaming at Christian Obumseli, "You were lying again," this is a tough one. This is going to be a tough one for the defense to overcome. So that's a little bit there on justifiable use of force. Now, again, even though a lot of people look at Florida as some scary standard ground state, and I think there's this misconception that if you're in your home, you can pretty much do whatever you want to protect yourself. That's not the case. More importantly, when we talk about something like Christian Obumseli and Courtney Clenney, they were in a domestic relationship with each other. Courtney Clenney and Christian Obumseli, whether Courtney Clenney's name was the only one on the lease or not, and whether or not she was the only one paying bills, if his belongings were there, his personal belongings were there, if he reasonably had the right to be there because he had been living there, staying there, and there was no other standing protective order in place that would say, hey, you can't be within this, be at this property or within X amount of feet of this property where Courtney Clenney resides, then he also has the right to be in that dwelling. So even though the state, the prosecution, will have to overcome the self-defense arguments, justifiable use of force arguments put forth by the defense still has to put the arguments forth. And they're going to have to say, Courtney was innocent. She was acting reasonably, as any person would. She was acting proportionately to what Christian Obumseli was doing. She didn't just have an irrational perception that she was in fear of her life. It was a reasonable perception. And even though she had a right to be in that apartment, so did he. So there is some element of avoidance at play. If he, and this is from Courtney's own words, but if she sticks with the story that, yeah, he stopped what he was doing, he walked away, he let me stand back up. How did things continue to resume at that point? That's a gray area. And you don't want to, as the defense attorney, you don't want to let the jury fill in the blanks for themselves. You need to have an answer to give them. So even though it's the state's burden of proof to prove the elements of second-degree murder beyond a reasonable doubt, again, that's really that malice aforethought. We have someone died, and we need to prove malice aforethought is what led to that person's death. We don't need to prove premeditation. And again, we don't need to prove that it was Courtney Clenney that killed Christian Obumseli because she's admitted to it as part of self-defense, right? You're admitting, I did that, but it was justified. So even though the state is going to have the burden of proving those elements, the defense has a huge uphill battle to climb, not just in my opinion, but I would say in any self-defense case. I would say in even a pure self-defense case, there's always a risk that you can be convicted. But in this case, we have the extra layers of who was provoking, who was the aggressor. Was it reasonable? Was her action with the knife proportionate to whatever Christian Obumseli may have been doing in that sequence of time? And ultimately, no matter what arguments the state and the defense put forward, the determination is in the hands of a jury. And the jury could find, hey, we just don't believe that this was proportionate. Or they could decide, hey, maybe we think she was the aggressor, but in the moment things changed and he escalated and she probably did fear for her life. Something changed. And suddenly in that moment it became reasonable. There was imminent threat to her own life, or she was in fear of great bodily harm in that moment. That split second can change the way a self-defense case can go. So overall, self-defense, justifiable use of force cases are always really interesting to follow because so much of it comes down to a minutia of time and what happened in that instance. And often what happened in that instance is up for interpretation by a jury. So overall, I hope you enjoyed this conceptual breakdown, right? This is supposed to be educational. It's a refresher. It's a look into Florida specific statutes, but also some general conceptualizations. But if you are following the Courtney Clenney's case specifically, I hope you hit the like button. I hope you hit the subscribe button. And I hope you join us as we revisit the bond hearing, any ongoing motion hearings that are coming up, and then when the trial actually starts. I hope you join. I plan on streaming it now. I didn't plan on it, but the case got interesting to me, so here I am. And before you go, if you want to share your thoughts, put your juror hat on, put your prosecutor hat on, put your defense attorney hat on. What are your thoughts on anything that we talked about, or any thoughts you have on the Courtney Clenney case itself, how you think it's progressing, what you think will be argued in court, or what you think the state and or the defense should stay away from and not highlight in their own arguments? Whatever it is, the floor is yours. As always, you guys take care until next time. I hope to hear your thoughts in the comments and hope you subscribe and come back to another video in the future. Take care. Bye-bye.